It's a good question. It's relevant, and we do this all the time, okay? In every state except for North Carolina and Louisiana, there's a 2-year statute of limitations. In those states, as far as Louisiana and North Carolina, it's 1-year statute of limitations. Everywhere it's 2 years, guys. So this question is relevant specifically to that question, and I'll explain. Is it worth it to file a complaint if you removed your child to homeschool? For background, student on homebound status, as outlined per their IEP, but never assigned a teacher, therefore failed all classes for the semester, hard to recover from grades like 20s and 30s. If disenrolled to homeschool, does it make sense to even file a complaint? Yes. Because what you can recover is remedial or compensatory services, and that can be very, very tailored depending on how you negotiate it. And so we've done it in an array of ways to where the school is providing a very targeted and specialized services per the parameters of your mediation or your settlement negotiations, in an allotment of hours, one-to-one for the child at, let's say, a mutually agreed location. It could be a public library, but the child doesn't have to be enrolled in school. You have that 2-year statute of limitations, and we always look at that. We always look at the past IEPs. We never look at the current program, guys. Because most of these problems that are occurring in the cases that we have, they didn't occur overnight. There's going to be a historical trail as to why we're in the situation that we're in. And that's what we're trying to fix. But if the child isn't no longer there, it doesn't mean that your 2-year statute goes away, and it doesn't mean that there's a requirement that you're enrolled in the school at all. Because your child was enrolled. And the school didn't do what they were supposed to do for your child. So therefore, yes, we can go after remedial and compensatory services, and we can target it and tailor it. And so, a lot of parents go, well, I want, them to pay for X, Y, and Z. Sometimes you can. It depends on the parameters and the details and the issues in your case. But at the same time, a lot of our hearing officers across the country, I'm talking about the majority of them, are going to follow the basic standard of recovery. And the basic standard of recovery is that the school gets their at-bat to fix it, guys. You don't just automatically out of the blue get access to wonderful $40,000 a year reading programs at a private institution, paid for by the school, if this is your first due process. And there typically is this idea and this established set of parameters, for lack of a better word, I keep using it, with the hearing officers, to where the school is permitted their ability to provide their at-bat. We're going to fix it, okay? This is why your dispute resolution options are so critically important. And parents, I know that a lot of parents are afraid to sit there and trigger any of those. But if you're in disagreement of your IEP and the IEP program, and you don't do anything about it, it's presumed until you do file a complaint that there was consensus, that you agreed with the IEP. Now, you have the 2-year statute of limitations, so therefore, yeah, if you file a due process complaint, you can go back those 2 years and you just say, well, I didn't complain then, but I am now. And this is the reason why. My child didn't make tangible, measurable progress, and, we need recovery. But let's say in this particular situation, you're sitting there going, well, I'm just going to homeschool my child. And at that point, that's fine. It doesn't mean that you can't go after the school during the time your child was there, going back 2 years for that analysis, and then at that point, fashion what recovery can help you and offset the costs that you might absorb homeschooling, okay, in the form of very targeted services for your child, defined in the way that works, and the schools do that all the time. Or, in the alternative, we'll negotiate a bank of funds to where you can find a third-party tutor, third-party provider, a location, speech language, OT, let's say a behavior analyst, a reading specialist, for example, and the school sets aside a block of funds. That's not going to be an exorbitant amount, guys. I mean, we got to stay within the parameters of reasonableness, but it's at least something. And then you can access that by having whoever you find establish a vendor contract, which is very easy, guys, with the school system, to where they provide the services and send the bill to the school. The school then pays that bill, and then your account balance, whatever that blocked amount of fund, just continues to go down until it's depleted. Now, usually there's a time frame that's inserted in there. You have to use it within a certain amount of time. But, with regards to the school just cutting checks to parents, they don't do that, guys. Schools are audited. How are these funds supposed to be used? So that's why blocks of funds can be made available that the school controls. They pay your invoices. There's got to be proof that these services have been provided. They can reimburse mileage, for example, meaning that they will cut you a check for things like mileage, and they will reimburse you, for example, if you've taken on personal costs with regards to evaluations or even some educational expenses. Those things are permissible. You can go after and get recovery for those things. Damages? No. Can't get damages, guys. Not under this law. This is remedial, compensatory services, and reimbursement. That's what this is about. But if you're choosing to homeschool and you have your statute of limitations, your child does not have to be enrolled for you to take action to get recovery and some satisfaction. We do it all the time.